If your wages are being garnished, I'm going to tell you how you can get that money back if you're contemplating filing bankruptcy. And that's the topic of this video. Hello again, everyone. I'm attorney Robert Flessis. If you're new to this channel, now is the best time to subscribe, because if you do subscribe right now, you'll know where to go to get answers to your legal questions. After a creditor sues you and obtains a judgment, the next step, if you're employed, is for the creditor to garnish your wages. Depending on your state law, a creditor can take up to 20% of your gross wages each pay period. That's a lot, and most people can't afford to lose that money. In fact, that appears to be the triggering event for people to file bankruptcy. But there's a way to get that money back from that creditor when you file bankruptcy, and I'm going to tell you how. This is the theory. Assuming that you have other debts that you owe to other creditors, the creditor that garnishes your wages is receiving a preference payment over the other creditors. What that means is that if there are other creditors that you owe money to, the payments to the garnishing creditor are payments being made that all of your other creditors don't get a share of. The garnishing creditor is receiving preferred payments over other creditors. If the garnished amount was over $600 during the period of 90 days before the filing date of your bankruptcy, then you're entitled to recover that money from the creditor. Here's how you recover that money. First, you look back at your pay stubs for a 90-day period preceding your anticipated bankruptcy filing date. The garnishments will appear on your pay stubs. Then add them up over that 90-day period. If they're over $600, then you're in business. A lot of times the garnishment is well over $600, and that means you get more than $600. That garnishment total you added up is now entered into your bankruptcy petition as an asset on your property schedule. And if you have enough exemptions, then you could use those exemptions to cover that money from the trustee's reach, meaning the trustee can't take that money from you and pay it to all of the other unsecured creditors. Now you file your bankruptcy case, and the next step is your creditor meeting, commonly referred to as your Section 341 meeting. At the conclusion of that meeting, if the trustee determines that you have no assets to recover from your bankruptcy estate, then you're going to get that garnished money back for sure. But there's a procedure that you need to go through in order to get it back from the garnishing creditor. You need to send a letter to the creditor or the creditor's attorney demanding the return of that money. You include in your demand the itemization of the garnishments from each paycheck from the date of the filing of your case and back 90 days. You don't need to provide each pay stub. Just make a list of the dates of the garnishments and the amount. You also have to include the docket entry that shows the trustee declaring your case to be a no-asset case. Send the letter in the regular mail, and within a few weeks, you'll receive a check from the creditor in the amount of the actual garnishments that were taken during that period. That's it. I'm attorney Robert Flessis. Remember to subscribe, like, and share. Thanks for watching, and I'll see you in my next video.